Part 2. The legal framework for ADR in the United Kingdom. In this module we talk about the legal framework for ADR in the UK. The international legal framework for ADR is covered in Part 4. When we refer to the legal framework in the UK, we are referring to a concept known as the seat of arbitration. This is a term used to describe the jurisdiction under which the arbitration is conducted. It does not refer to the physical location as to where the arbitration is conducted. The seat of arbitration is also distinct from the applicable law under which the contract operates. It is important to note that the ADR cannot be used to deny a person's fundamental rights to justice. The right to justice before a court of law is a right prescribed in the Magna Carta in 1297. The Arbitration Act 1996 provides the legislative background in which arbitration operates in the UK. In England and Wales, Part 62 of the Civil Procedure Rules 1999 sets out the procedural rules by which the courts deal with claims arising from arbitration. The Act sets out the operation of arbitration as well as the mechanism for challenging the enforcement of arbitral awards. The rules provide the procedure before the courts. In a consumer context, there are information requirements on traders to give consumers about ADR. This is set out by Regulation 19 of the Alternative Dispute Resolution for Consumer Disputes (Competent Authorities and Information) Regulations 2015. It is important to remember, however, ADR itself is not mandatory, only the trader's obligations to tell consumers about it. There are moves to make ADR mandatory. The Law Society Gazette reported on the 12th of July 2021 that according to the Civil Justice Council's report on compulsory alternative dispute resolution, mandatory dispute resolution is lawful and should be encouraged. The report was commissioned by the Master of Rolls in January 2021 and concluded that mandatory ADR is compatible with Article 6 of the European Human Rights Convention. Lady Justice Asplin, Chair of the Judicial Liaison Committee and lead judge for the ADR, said, "This report addresses questions which are central to the shape and design of dispute resolution in the 21st century, and that they had concluded that ADR can be compulsory." The High Court does not have any significant record of dealing with consumer disputes, so it's no surprise Lady Justice Asplin was looking in the wrong direction when forming a view on it. A good working knowledge of the Consumer Rights Act 2015 would be more useful in this context. This is because legal proceedings in the High Court may only be commenced if the claim is expected to be more than £100,000. That figure makes consumer disputes before the High Court extremely unlikely. So therefore, contrary to the message from the Judicial Liaison Committee, and certainly in a consumer context, any attempt by the trader to restrict or limit a consumer's right to take legal proceedings would be an unfair contract term. Under Section 62 of the Consumer Rights Act 2015, the requirement for terms to be fair, an unfair term of a consumer contract is not binding on the consumer. Section 63 deals with contractual terms which are regarded as unfair. Reference is made to Part 1 of Schedule 2. Paragraph 20 in Schedule 2 refers to a term which has the object or effect of excluding or hindering a consumer's right to take legal action or exercise any other legal remedy, in particular by requiring the consumer to take disputes exclusively to arbitration, B. Unduly restricting evidence available to the consumer, or C. Imposing on the consumer a burden of proof which, according to applicable law, should lie with another party to the contract. Therefore, only Parliament can make ADR mandatory. This would involve a repeal of some of the provisions contained in the Consumer Rights Act in relation to unfair terms. Having said that, some form of mandatory ADR will be coming soon as dispute resolution is moved online. In future, legal proceedings will only be available, if at all, after the parties have engaged in some form of ADR. It is too early to say whether this will follow the example of the federal courts in Australia, which require a certificate that ADR has been completed before legal proceedings can be started. However, a similar model will probably apply.